Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Good morning, friends. Good morning. I'm here. Court also went ahead and just got started this morning. So remember, the judge and the lawyers are supposed to have some arguments about the New Jersey versus Tier issue from yesterday. Hold on, let me get my stuff together. My dogs are being just the worst this morning. Probably because it's like warm out. And they're like, oh, we're just going to be outside with the snow melting. I can't wait for them to be covered in mud today. I'm having a morning, y'all. This is definitely why Mama does not get, I got it, buff. This is why Llama doesn't get up this early, because things go into chaos. Hold on, let me find, okay. All right, let me move this up here and we will go ahead and begin. So let me see, hold on, this one. And, well, that's just me. Oh, there we go. Okay. I think I did it. All right. Let's see what they have to say this morning.
Record State of New Jersey versus Paul Caneiro. It's indictment 19-020283. Can I have the appearances of counsel for the record?
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good morning, Judge. Chris Decker, Assistant Monmouth County Prosecutor.
Good morning, Monica Mastel on behalf of Mr. Paul Caneiro, who's present.
Good morning, Judge. Good morning, Mr. Caneiro.
Oh, he's wearing that brown suit again.
So, yesterday, Caitlin Caneiro was on the stand, and during the course of her testimony, a few things came out that gave the court some concerns, and there was some objections that were made. As it relates to the testimony, I'm going to reiterate it. To start with, this deals with the Jennifer's phone and Caitlin testifying about the phone call that she made on the day of the incident. It starts off with defense counsel, specifically with respect to Jennifer's phone, was her phone ringing? Witness says, yes, it rang normally, then went to voicemail. Defense counsel, what was the approximate times you were calling the phone calls, the phones that morning? Witness, I would say from 9:30ish to 12. Defense counsel, okay, that's approximate. Answer, yes. Defense counsel, okay. And to your recollection, did Jennifer's phone ring? Answer, yes. Monica, or defense counsel, were you also sending text message that morning? Witness, yeah, I texted my Uncle Keith and I texted my Aunt Jen. Question, do you remember the time that you sent your Aunt Jen the text message? Answer, no. Question, no. Answer, no. Question, would seeing a copy of the text message with the timestamp help refresh your recollection? Answer, yes. Question, I am approaching with what's been marked as D1-54. I'm just going to direct your attention to the name. Answer, okay. Question, and the specific text with the timestamp? Okay. I think it's D54. Question, okay, does that help refresh your recollection of what time you sent the message to your Aunt Jennifer? Answer, yes. Question, and what time was that? Answer, 10:26 in the morning. Question, okay, now what kind of phone did your Aunt Jennifer have? Answer, she had an iPhone. Question, and do you still have that text message in your phone today? Answer, yes. And did you look at that text message recently in the last day or two? Answer, yes. Question. Now, prior to the last day or two, when was the last time you looked at that text message? Answer. The day I sent it, November 20th, 2018. Question. So you haven't looked at the message since? Answer. No. Question. When you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question. Or excuse me, answer. It's an iMessage and it changed from delivered to read. Question. Okay. So do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer. No, I didn't look at it for 7 years. Question. Now the fact that it said read, did that stand out to you? Answer. Yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of
Morning, Pam.
not just this colloquy back and forth, but the next colloquy that goes on the record,
Word
which
of the
deals with
day.
Jesse's iPad.
I can't say.
Question,
Morning,
again,
Jesse.
same witness, Caitlin Caneiro. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was when you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this.
I heard a rumor.
The state's brief, which I received somewhere around 8 o'clock last night, was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone, to include the actual text message that was marked red and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion, which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the state, which it never was. And because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response. And the defense's response, for the first time, defense counsel admits that she had an actual screenshot of the phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour, and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence about
That's what I heard.
that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble.
And I heard that they weren't letting
Of course,
Jennifer's
this
family in
was
there.
dealing with when Vogt collected the DNA samples in 2020, not in 2018.
By the way.
Second, the state argues that it demonstrates, if this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out, I want to go back for a minute to the text message. There was one thing I did want to add to that. In the submission, no, I don't need to go back. In the submission, it also points out that that when Katie learns of the location in February of 2019, that she sees that the location was at Corey's house. There's a footnote that the defense counsel talks about, which says it should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it either via text or phone once she saw it that he had the location, and asked him why he had taken Jesse's iPad. That is the first time and only time that the court is aware of that either there is a documentation in a phone of either a text message or a phone call in Keith Caneiro's phone that could corroborate or provide information that could be investigated as it relates to the issue of whether that occurred or not. That either text message or phone call was not turned over to the state, and if was turned over, they can tell me when they start to argue. I should point out that the defense is, in saying everything that I've summarized so far, the defense is saying that they are not suggesting that the iPad was taken at the time of the murders, as it was clearly depicted during the testimony of the forensics detective when he went through the evidence found in the kitchen, where there was an iPad located there. The iPad, I guess, based upon what defense counsel is saying, is that the iPad that's located in the kitchen is actually Jesse's iPad. I don't know if that was clear during the testimony at all, that somebody said specifically that they knew that it was Jesse's iPad, but that also is something that's being argued. But what the defense is saying, that they were trying to be careful to make clear to the jury that Katie saw the location in February 2019, a few months later, so not to be misleading. However, there was no context to this as to when, at that point in time, how long that the location was at Corey Caneiro's house for this iPad. It truly was unclear because we didn't get that far based upon where we were. Defense counsel further argues that the state had full access to Susan, Katie, and Marissa, that the state had the ability to interview them just as much as the defense did. However, what's interesting to note about that is that it's clear from this submission, and it's noted specifically as a footnote number 3 on page 4 of the defense's submission, that the defense was aware that the state was making efforts to speak with Susan and to Katie and Marissa close to the time of trial to make a decision on whether probably if they were going to call them or not. However, that none of them were willing to speak. So the state did not really have access to them. So when it comes to the defense putting in their submission that for the weeks during the course of the beginning of this trial, that they were not sure if the state was going to call the either Susan, Katie, or Marissa, court has some level of concern of that statement based upon the fact if the state had no idea what these individuals were going to say, why would they call a witness that they have no idea what's going to come out of their mouths other than a statement that was given 7 years ago, but now they're unwilling to speak to the prosecutors. So I'll leave that for another day or for the state to deal with if there's something that should be added. I'll point out that while the state did have Susan, Katie, and Marissa are on their witness list, the witness list is a list of people that may be called. It's not it's more people that are ever involved in a case. The witness list is used not just for the potential witnesses, but it's also for the jury to know, to be read each individual's name, so that if one of the jurors happens to know one of these individuals that may not be called as a witness, it's still important for the court to question those particular jurors as it relates to that issue on whether that if they knew that person, even if they're not being called, would that have impact their ability to be fair and impartial? So the fact that the Susan, Katie, and Marissa were on the state's witness list is of no moment to this court as it relates to
That makes me think of rumors I heard.
them being there, and as to whether that there was an obligation here to turn over this type of evidence. I also want to point out that counsel brings up the fact that, well, this trial is moving exceedingly fast. I just want to say that I've disagreed with that from the door. I gave the March 20th date because everybody indicated that that's how long the trial would be. It was never what the court thought how long this trial was going to take. As the trial went on, it was clear that this case was moving quickly. As early as the first week, it was clear that this case was not going to take as long as what was being said. Of March 20th. So I don't find that the movement of the case in an expeditious way was any surprise to any of the parties as we move forward as to when the prep of Katie was done or how ultimately we come to the conclusion of where we are today. So defense also talks about state versus tier, and I'll get into that when I give my ultimate decision. And lastly, the state says that that it doesn't believe that it violated any reciprocal discovery, but if it did, that it should be a brief continuance instead of a violation that bars the actual testimony.
I thought we were going to get closings today.
There was 2 exhibits that were supplied with the defense's submission, which includes, again, a photograph. In Exhibit A was a photograph of the kitchen area where the defense is indicating that Jesse's iPad was located on there. And then, again, that's what the defense is saying. And then second was the actual screenshot that was never turned over. I summarize what people have said so that we don't need to reiterate the actual arguments. However, considering that the state submitted their submission before the defense, I don't know if there was something else that they wanted to respond to, but I'm going to allow both sides to create their record before the court makes its ultimate determination. I'll start with the state.
Thank you, Judge. Now, I just want to start off by saying that I think that the court's summary with respect to the issue that came up yesterday and the court's summary of what was stated in the briefs is spot on. I mean, I think that the court essentially hit every point that the state would have argued. Obviously, the state and the defense in any case have different discovery obligations. We're all aware of that. But that does not mean that when you are in possession of a document that you decide not to turn over because you weren't going to use, it doesn't mean that it's not a discovery violation. I mean, they did use it. They didn't use the physical document, but they used the information in there. That's where the state has a problem. I don't want to get on my high horse, Judge. I'm not going to belabor the fact because the court's spot on in its insight with respect to everything that it said this morning. But as someone who's been with the prosecutor's office for almost 23 years, especially in the last few years, I've had to sit back on cases that were not mine, some of which I then had to get involved in, where the prosecutor's office was being accused ad nauseum of these heinous discovery violations, when in effect, a lot of times it was essentially some sort of minor oversight, clerical error, but yet in the press, the state and the prosecutor's office was looking like the demon, the villain. I'd submit to this court that over the course of the last 7 years, this office, myself, Ms. Wallace, paralegal team, my clerical staff, have done everything possible to make arrangements to provide discovery to the defense. I've been personally, not by these attorneys, personally had my credibility tarnished, or attempted to be tarnished, by a prior attorney from Mr. Caneiro, wherein I had to write a very scathing letter pointing out that in fact we did not have something at a certain point that we were accused of having and not providing. We provided discovery. It's been gone over ad nauseum by Your Honor, by Judge Oxley, every status conference. Is there any other discovery? We've done everything we can. I'm not trying to make this more than it is, but I think based upon the submission that we've received from the defense, certain things are clear with respect to what they had. And I would submit to the court, as I stated, that I don't believe that the New Jersey Supreme Court in tier intended for their opinion to mean that, hey, let's not document it because then we don't have to turn it over. I don't believe that's consistent with the language about encouraging practitioners to participate in cooperative discovery, et cetera. It's pretty clear what we have here. It's a clear situation. The court's insight is spot on with respect to the Susan and Katie and Marissa. You know, a lot of what Ms. Massalone said is accurate. We did make attempts, and just because we didn't, Detective Petrozello or Detective Weisbrot didn't document every effort over the course of the last 7 years to make contact with the family, doesn't mean it didn't happen. They know it happened. We tried our best to not harass them, certainly, but we had made efforts. Ultimately, it culminated with, we were supposed to meet with them on the Friday before the first trial date in September, and it was canceled because we were here arguing whether or not Mr. Caneiro would be released.
Hi, Cassandra.
Then, prior to trial, we made efforts again. I did speak to Ms. Pastalone about it. She said that she was in contact with them and would tell them to give us a call. Ultimately, Ms. Caneiro called Ms. Wallace back and indicated that she didn't feel comfortable talking to us. So they were on our witness list, yes, but as the court noted, properly noted, that we can't put witnesses on the stand when we don't know what they're going to say, i.e. exactly what happened yesterday. This is not information that was provided to us. It was not known to us. We would have objected to the first part of the testimony yesterday had we known it was coming out, which we did not, obviously.
It was.
And then obviously it became clear with respect to the iPad location and that clarification that she saw it in February of 2019 does nothing to clarify to this jury when that iPad was taken by Corey Caneiro or his wife or whomever who actually had control of the property after the scene was released by virtue of the executive status. That being said, Judge, I'm not going to belabor this anymore. It's clear exactly what we have here. There was a document, it was not provided, and there's other information.
Let me ask you this question. If the court felt compelled that it had to allow some of this information, even if I do find a discovery violation, I just want to know the state's position as it relates to a need for time to investigate some of this information that you're literally learning 5.5 weeks into a trial.
Judge, the testimony yesterday that she looked at, all of a sudden she looked at a text message and said read without the document. I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
You do, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Judge, I worry about the credibility of what's been provided.
It'd be in the kitchen, Lainey.
I have no idea, nor am I ever going to be able to know. No time is going to allow me to figure out how that became read. It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Walls would disagree with me, that time is going to do anything at this point in time.
Okay.
It's not going to allow me. I know I can find out when Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message after the fact. It's just that document is just clearly inadmissible. Whether the court ultimately tells the jury to disregard the testimony about it, that would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Massalone, would you agree with me that the document, the screenshot that you had was an electronically stored document within Katie's phone?
The document that I had, Judge, was simply a screenshot of what she observed in live time.
So, but my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document. Right?
I don't know if that's within the context of the discussion.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
In my opinion, it is electronically stored in her phone. Yes. Is it electronically stored as far as do I have access to her phone? I didn't have access to her phone.
well, actually you did, because you actually got a screenshot of it, according to you, the day before. So you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time. And in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it, but I didn't think it would be fair to surprise the state with this document and say, I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So yeah, you did have time. You absolutely had time to turn it over. And it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. Tier says one thing, it does. But Tier does not mention, and it does not deal with the fact when something, it's not created by you. No one's asking you to create anything in this case. It already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This in this court's opinion aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it and you didn't turn it over. So if your answer is anything other than when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I can say.
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance. So the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this.
Now this is heated, long.
I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019, she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point, but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record's clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using.
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate, to refresh her recollection, would have been what you had in your possession, which was the screenshot, which included underneath the word red, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form.
It's true.
The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the
I'm just
context
a
of the
normal
conversation
lawyer.
and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record, as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions.
Yeah, we barely went to sidebar, actually.
Testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There was a 25-page ex parte letter that pertains to Corey Caneiro. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post
I want the ex parte letter. Somebody find
behavior
out for me.
by Corey and/or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, that's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking.
Oh, man.
The first thing that you say.
I don't know if I've seen a judge this pissed before. I don't think so.
Deals with the fact that they are in the home.
Me either.
They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020. A contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house?
Nobody.
And getting stuff out?
Nobody. Mm-mm. No girl.
Judge.
The answer is nobody.
It might have been a mix between Petrozello and Detective Vogt.
Nobody.
I think there
Who
was.
specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no...
You know what I'm asking you. We're not talking about AIG. We're talking about the fact, what's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
I mean, at this point in time, I don't specifically.
Yeah.
I don't have a recollection of exactly where that came in the trial.
Probably
I
in
know
one of your
it
3-minute long questions.
I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure.
It didn't.
I know it's a fact
I'll say it for you.
I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case. But number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission, because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not saying that I'm right. That's why I'm asking these questions, because I don't think it exists and I may be wrong. So if you tell me that it exists, I will go and try to find it. No, otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony. And really, I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible, piece of information, I don't know. It was in the discovery, and they don't have the iPad. So, from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone. I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple of days before, about the iPad.
A couple of days before.
That she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutors, is there something you want to say before?
Judge, I just want to clarify something that really is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire. That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who, went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds at school. So that's just to close the record in that regard.
Wow.
I'll be back.
Hold on. We're behind, so
Let's not bring up the jurors yet.
let's not bring up the jurors. Oh,
Yeah, he needs to calm down. He doesn't want them to see him this mad.
not back yet.
He's
Holy
like, they can't see me like this.
Oh wow, he's so mad. He's so mad.
Well, I think one of the reasons he's so angry is because they already had that tier discussion,
Yeah.
you know,
Mhm.
and he knows, and he's like, he's pointing out, this is different because it's electronic. It doesn't fall under that.
Right, which I read
He
the link
knows
you
that.
sent. Mhm.
That's why
If
it's the
it's-
mad thing.
If it's something that is written down in any form, it's to be turned over to
Exactly.
the state, which is different than the argument they had a few weeks ago regarding what Susan said about, allegedly said, because she hasn't testified. That was different because that was just her word, her recollection. And that's why
Right.
those were two different things. But oh boy, I don't know if I've ever seen a judge lay into somebody like, he must have been one hell of a prosecutor, I bet.
I mean, even Bev, when she got really mad at AJ, wasn't that mad.
Mm-mm. No,
I mean-
he used his dad voice and everything.
I know.
I'm going to give you one last chance. Oh,
Yes
Monica.
or
Betts.
no.
Whew. Well, we're all going to be having a better day than Monica. It's not coming in. By the way, if nobody picked that up, the judge is going to be like, nope.
But what does he do about what they've already heard? I mean, he can tell them they can't.
Mind
consider it, but-
erasers, obviously. You know.
Well, here's the thing too that bothers me. He told them they couldn't bring up anything to do with Corey's actions or what anything he did.
Mm-hmm.
She was supposed to tell the witness not to do that,
Yeah.
and either she didn't or the witness ignored her. Which, I mean, witnesses are going to do what they're going to do.
That's true, especially family witnesses.
Yeah, because I'm
I
sure
think
she's
they're the
definitely
worst and
trying to point the
hardest.
finger at Corey. I mean,
Mhm.
and I'm not saying that I blame her.
Oh, yeah.
You know, it's her dad. I
But
understand that.
family witnesses are always uncontrollable. Like they could, because they're so emotionally invested and involved
Oh yeah.
in things. That's why
Yeah.
I wasn't sure if they were going to put Corey up for the state because again, like they're wild cards no matter what, because you can't predict how they're going to be once they're in that seat because that's a whole different,
And what's going to happen under cross. But the thing
Mhm.
is, state hadn't had a chance to cross her on anything she said.
You're not yet, no.
Is he going to throw her testimony out altogether and not let them cross?
I don't know.
I don't either.
I don't think so. I wouldn't think so. Now, a few weeks ago, I saw some rumors about Corey. I don't even know if they're rumors. Maybe they're facts. I don't know. I didn't verify them, so I just assume that they're rumors. About Corey in particular. I heard that after the fires, Jennifer's family wasn't allowed to go in the house that Corey was, and they weren't allowed to go in to retrieve antique jewelry, like family heirlooms from there, and that they were really upset about it. I heard that he he then bought like a $1.6 million house or something like that, like right after that. And I was like, oh, that's probably just rumors. But I did not connect the dots with the Tiffany boxes, implying that they were accusing Corey of throwing the Tiffany boxes all in the bedroom, which we saw were like literally on top of all of the debris. But does that mean anything? I mean, he also got, $3 million. So, but I don't know. I don't think that's going to be enough to save Paul.
One thing is, he was the executor now, wasn't he?
That's my understanding.
Okay.
I don't know for
well,
sure,
then
but I
that
think
jewelry
so.
was technically part of the estate now.
Mm.
I mean, if you want to get technical and legal about it and kind of be a jerk about it, you know what I'm saying?
Because I think
family jewelry is one thing, in my opinion, because I think anything that, I know it is in Tennessee, anything you get in inheritance is not considered marital property. It's yours.
Right. Mm-hmm.
But I don't know that she got this as an inheritance. You know what I'm saying? It's all that weird kind of stuff. And I have no idea what New Jersey's laws are like.
Because I think I'm going to... I'm looking for the lawsuit. Okay. Well, I mean, Asbury Park, I know, but like, I'm not going to do that though. Her husband's older brother was stealing. I feel like the father is suing Paul and Corey, but I don't know now. I'll have to look it up during like our break or something like that. I had the lawsuit somewhere. I don't know where though.
On behalf of Olivia, right? That's what you're
Sophia. Mm-hmm.
Sophia, I mean, not
yes,
Olivia.
yes.
I don't know where that came from.
That's okay.
I can't. I need more coffee, obviously. Whew.
Today was so spicy. Oh my gosh. Now I had a theory that was the trustee there linked to 3 million whole life insurance policy. Okay, yeah. I was thinking today we might get opening statements, but I don't know now. So I don't know. Oh, what's
okay, let's think about this. Once they get this settled, who else do you think the defense might call?
I don't know.
I don't know. She's going to call any more family members.
I mean, maybe.
I don't know. Not be afraid, because were they sitting in the courtroom when this girl was testifying?
Yes.
Do you think she talked to Monica last night? Even though she's not supposed to.
I don't know how you don't, to be quite honest.
Not after that happened, yeah.
Or her mom or sister. I mean, to be quite honest with you, maybe not. I don't want to accuse her of things, but
no, I don't either.
I wouldn't be surprised. What was the other thing I was going to say? Oh, so yesterday, right? Remember Court TV at the beginning of their feed yesterday, who, by the way, is not live again with Caneiro today. Just putting that out there. Because remember, they ended their stream early yesterday for some reason. And then I went to look not that long ago, and they weren't streaming at all this trial. So we learned yesterday that there was like a merger between Law and Crime and Court TV. Maybe
they're waiting for when the jury gets in its testimony, but this is much better than anything we've seen.
Oh, they don't have anything set up for today.
Okay.
Oh, no.
Well, they're going to be sorry they missed this. You talk about ratings.
Well, they have the teen killing spree sentencing that they don't have up. Like the Caneiro. So I don't know what's going on over there. But yesterday morning, the beginning of their thing said day 16 in closing arguments.
Right.
Remember that? And then at the end of the day, the judge was very pissed and said, well, I was going to give them a day before that in summations. And now I'm not going to do that anymore. Which the only reason you would say that would be you had to bring them in today. So I don't know. Maybe
That's true. He may have been going to give him like today off or something.
Because I
Get
heard
ready.
I heard again a rumor at lunch. Maybe I should believe a little bit of these rumors, but I try not to. When we were at lunch, I did see on the Reddit that Court TV, somebody said Court TV said the daughters are going to testify today, or a daughter. I don't remember if it was daughters, or daughters. I don't know. But that they were going to take the stand. And I was like,
You were like, no.
no way, And sure enough, they were right. So maybe they will today. I don't know. The state is not going to push a continuance or anything like that. So
Not this close. No.
No. Yeah, I don't think. I mean,
He'd probably offer them if they wanted today to do anything, but they're going to probably say no. They don't need to. Really, because he's going to not allow that. I'm with you. He's going to say no.
Mm-hmm.
No.
He's saying no, and he's going to strongly say no.
Yeah.
But the prosecution is dressed very sharp today.
Oh yeah. He knew he was going to be on camera, didn't he?
Yeah, they're just very sharp today. I do love Monica's outfit again today.
Well, she
It's
always
very
looks
cute. She looks
wonderful.
great. I know. She has great style.
Mhm.
But Nicole wearing red, we're matching today, wasn't even planned. I actually wore this for you, Terry, if you're listening, for Valentine's Love Week.
Well, I got pink nails for Valentine's.
Oh, look at that. That's fun. And some
With
glitter ones
Some
too.
glitter ones. See, look, Terry, pink and glitter. What do you know?
Well, she's ripping off on all of us. Oh my gosh. You want to hear what I did this morning? This is just how my morning was going. I was like, oh, I'll wake up early because who knows? And then, of course, I was like, of course, I'm going to wake up early and it's not going to be anything, right? Of course. But I wake up way earlier than I do at like 7. And I went to make coffee because Elbow Feet made no coffee.
Now we're going to have a chat.
I know. I think he took all the coffee and then didn't make another pot of coffee. Right. So I go to make a pot of coffee and like, you know how like they'll have like the insert and then you put the filter and then you put the coffee, right? Well, guess who didn't put the insert? Just put her filter in the coffee and it brewed some very dark looking coffee and like the coffee grounds. When I pulled yes. Well, when I pulled the pot back, right, there's a hole and the coffee filter just goes through that hole. And then there's just coffee grounds everywhere. And it was hot. And I was like, oh my gosh. Now I got to wait another 20 minutes.
But you have to clean it up first.
I did. And I wasn't happy about it.
I've done that before myself. So I know what you're talking about. It's like, today was not the day for that. No, this is why Llama should not get up before 8, really. So that was my morning. You thought you had time for a coffee, and then you get this message that says, "Oh no, they're on there. They're streaming." I was like, "I'm trying to eat my bacon and eggs. I'll see you in a few." My dogs were being ridiculous this morning. Yeah. Like since I woke up at 7, they'd been outside for like 45 minutes in like 2 increments, right? Like 25 minutes because it's 32, which is cold, but it's a freaking yeah, you're tagging me. The court's going. I'm like, I'm trying. I'm doing my best. Yeah, we'll blame it on that. He's not here to defend himself. That's right. So what a morning, but what a spicy morning. Oh my goodness. What day is this? 6/17. We've been waiting 17 days for something like anybody to get heated. And the judge did not disappoint. Woo. So I'm just doing my job. Yeah. So some of you, a few days ago, last week, it was when Andy was questioning the ballistics guy, I think it was. Was that it? Long Crime takes a clip from the testimony, and in their title of it, it's like heated argument between witness and the defense attorney. It was Andy, and like none of that was even true
At all. There was no, the word heated and Andy don't go together.
No, they don't.
And so now I
Wonder
wonder
what the headline would be today, because today was
now that's heated law and crime. There you go.
it's on fire. Lit.
Right. You scheduled an appointment with your surgeon and getting the scar laser on my girls, and it's going to hurt. Oh no. Oh no. Right before Valentine's Day, you're going to hurt the girls like that?
Today? You have it today?
That is not good for Love Month.
I don't think it's good for any month, especially Love Month.
Especially Love Month. Oh, wow. Interesting. Judge, right? He did use a stat. I know, because I've talked to my kid that way. I'm going to give you another chance.
Yeah.
It's either yes or no.
Yeah, I know. That's the part that got me. It's a yes or no answer. And she still didn't do it. I'm like, oh.
Stubborn. And then
that's
Andy.
a lawyer for you.
Andy just standing up like, I don't.
He said, well, I don't think you could get him. I don't know. If he got heated, it might be scary because I just don't see it ever.
I don't think he's self-aware enough to be upset about anything, to be quite honest with you. Oh my goodness.
No, he's something special.
That's what you're changing the thumbnail to. Nice. Oh, he's no nonsense. And at first they didn't even see Andy. Don't worry.
What if that had been Andy's witness to start with? Would he even fought back? You know what I'm saying?
Right. Like, well, okay. Oh, Terry says also to all the TCWT staff, you have something arriving in the mail. And everyone for glittered except Timmy / Buffy. Oh, I love that.
I like glitters on my nails because I can control it. It doesn't come off. See,
I know. I gotta paint mine too. Maybe I'll do that today, depending how today goes. I'm hoping they do closing arguments today. I mean, the defense, they don't have a shot at reasonable doubt right now. Like, I don't know what you could possibly pull up that it's like, oh, yeah, I mean, yes. Is it, weird that Corey took, I want to read the court documents, the ex parte and whatnot of what they weren't allowed to talk about and why.
I know, I'd like to read that too.
Because listen, Corey did have a lot to gain. He had just as much to gain as Paul, monetarily. Now Paul, though, however, had even more to gain. All right, is that theft, covering that up to avoid people knowing that he stole money or borrowed money, whatever story you want to believe. But either way, money was gone, and Paul had something to do with it. So I mean, that's a pretty big thing. Let alone not knowing. I mean, Keith probably wouldn't have filed charges against him, I feel, because of how close they were. But still, that's a risky, going to court for that.
If he stole from the company, he might not have had a choice. I mean, personal stuff and like his personal trust and stuff, I don't think he would have. If it had been embezzlement from the company, then he may not have had a choice if they had any stockholders. Not that's not the right word, but it's kind of like that.
I don't think he took any money from the company.
I don't think so either.
The trust.
The trust. So maybe he wouldn't have, but he might have if it'd been enough because it was his children's money. He's stealing from the kids.
I mean, that's a gamble, to think that Keith wouldn't turn you in for, it was like $80,000 or something like that. I mean, that's a lot of money. And the reason why I say I don't know if Keith would have turned them in is because the way Keith was handling the business and wanting to just be done and just move on,
Yeah, he was ready to go.
But, that goes in Paul's pile of stuff that Corey doesn't have, like, because why would, like Corey did know that day what was happening, because we do know that Keith sent an email to Corey. He had some communication with Corey.
Right.
We do know that. I don't think we've seen it, but the state has definitely talked about it. I don't know why Corey would just get it all together like that day. What?
Yeah, that's the thing. It was if it happened because of that email he sent, that was quick planning it. What did we know what Corey did for a living?
No, we don't know very much. We meaning I mean,
Yeah,
I don't
I
know.
don't
Maybe
either.
it's on the internet or something. I don't know. But between this trial and no, I don't know anything about him. So, I mean, a lot more is on Paul's list of reasons why comparatively.
Right. If you had to do a column board and you did Paul and Corey, Corey
and again,
have like one item.
the clothes are in the basement, like,
and his guns were used. The ballistics show that.
And listen, I'm still obsessed about the two men dressed in black with the hats that the two neighbors saw. I'm still obsessed with this fact, but maybe it's a red herring. They happen all the time. You know, maybe they just were two guys who happened to see the fire, tried to put out, and then just left and was like,
It could have been some people that shouldn't have been in that neighborhood and saw the fire and thought, God, we got to get out of here before we get blamed for it.
Yeah,
I mean, you don't know.
You don't know. The judge needed his stress ball. I forgot about the stress ball.
He needed a stress ball the size of a basketball or something.
Right. That's true. I forgot all about that. Man, we needed those on day 2.
Man. He was mad. I think he's mad because just from what he was saying, it sounds like he felt like the defense attorney was trying to pull one over on him, and he knew she was, and she knew better. I mean, I don't think he thought it was just I didn't, wasn't trying to elicit the document. I was just trying to elicit the testimony. I can't help what she said. He ain't buying that.
Yeah. No, none of us were buying that. No. Sorry, girl, but it was blatantly obvious. Okay.
I think that was like one of those cases of ask for forgiveness, rather than permission. But you can't do that in court.
No, you can't.
You know that when you're sneaking out of the house when you're a teenager.
Right. I mean, because stuff does, you have to show that, you weren't trying to cause harm, but I kind of feel like she was.
Well, this is harmful to Paul. I mean, it could be ultimately to his defense if the judge, depending on what the judge does. I mean, and depending on if the jury figures out in their mind that, or thinks that maybe she was trying to do something shady. Why is she trying to do something shady if he's not guilty? I mean, how people start thinking outside the parameters of evidence because they're human.
Yeah. Oh, I know. I read a lot of the comments that were out and about the daughter's testimony. I was just like, geez, you guys are real mean. Like, okay, I get it. She is a little standoffish, but like, who wouldn't be in this? And I mean, I don't get it. Like, I would be on guard too, but whatever. As she says, finally caught up. At one point, all I heard was, Mr. Gambini, the next words out of your mouth better be guilty or not guilty. I don't want to hear commentary, argument, or opinion. Oh boy, IG, what a morning, huh? Oh my goodness. Yes, Buffy said listening to them go back and forth was the most action this trial has had in 17 days. And Monica being like, I'm just called up for sidebars all the time. No, actually, ma'am, you're not. All right. We didn't even know you guys knew the word objection for like 8 days. Like, oh my gosh.
Oh, wow.
But Andy's big,
I'm not sure where it was or who said it, but somebody said, I don't like what the judge said. It's not what you know, it's what's been done in court, which I understand that too, because we'll sometimes talk about things we know outside of court.
Well, that's been one of my complaints on both sides, is that they clearly know this case inside and out, but
Right.
they're not acting like we don't, like, they're acting like we know shit too, both sides. And I think that's the reason why this case has been very hard to follow, because they're all so deep in it that they just
Right.
assume that everybody knows everything, you know?
And that's normal for them to be that way.
Mhm.
And they know things that aren't allowed in. And I'm not saying they forget that they're not allowed.
We're back in session.
They're perspective different.
You see?
Right? There we go. We're back. The first time ever. So yes, you're going to need to go back.
There was an
Right.
issue before the court yesterday. But the court summarized earlier an oral argument.
Get my coffee.
But did not render a decision on the admissibility of the evidence when it was brought up at sidebar. Instead, the court expressed concern that the information, having not been previously disclosed to the state, potentially constituted a discovery violation. The court directed both parties to submit written memorandum addressing both the admissibility of the evidence and the discovery issue. After reviewing now the written submissions from the state and from the defense, and also listening to arguments this morning and a review of the applicable case law, court will render its decision now. First, I want to start with the premise under State versus Knight 256 NJ 404 2024, quoting State versus Williams 80 New Jersey 472, 478 1979. Quote, the thrust behind the reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. With that being said, in looking at our New Jersey court rule 3:13-3B2B requires the defendant to provide to the state, quote, any relevant books, papers, documents, electronically stored information, and any other data or data compilations stored in any medium from or through which information can be obtained. The phrase electronically stored information is broad and encompassing a wide range of digital evidence, but it includes and is not limited to text messages, emails, photos, videos, location data, metadata, and other information stored in electronic form. Rule 3:13-3F provides remedies when a party fails to comply with discovery obligations. The rule states, quote, if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with this rule, the court may order the party to provide the discovery, grant a continuance or delay during the trial, prohibit the party from introducing in evidence or material not disclosed, or enter such other order as it's deemed appropriate, end quote. Critically, Rule 3:13-3F also imposes a, quote, continuing duty to provide discovery, end quote. In other words, discovery obligations do not end when initial discovery exchanges are completed. If a party learns of additional discoverable material at any point during the proceedings, including during trial, the party has an immediate obligation to disclose that material to the opposing party. In this case, the defense has relied on State versus Tier, where the Supreme Court held that Rule 3:13-3 does not require defendant to generate a written witness statement where none exists. That's Tier at 228 NJ at 568. Tier protects attorney work product, specifically written summaries or notes that defense counsel creates during the investigation. The court in Tier emphasized that that compelling defense to create statements would invade the attorney-client relationship, reveal defense strategy and theory, and violate the defendant's Sixth Amendment right to counsel. The court did not address and specifically did not decide what obligation a defendant has with respect to independently created physical or electronic evidence that exists separate and apart from any work product created by defense counsel. In Knight, the Supreme Court addressed a question Tier did not resolve. What happens when independently created physical evidence exists and defense has access to it? There, the court held that an affidavit not created by defense counsel must be disclosed under Rule 3:13-3B2B. The court indicated, quote, the affidavit is physical evidence of a crime. It's not the product of the defense investigation or attorney work product. Rather, the affidavit is a relevant writing potentially in defense counsel's possession pursuant to Rule 3:13-3B2B. There is no question that this type of physical evidence falls squarely within the defendant's required reciprocal discovery obligations. That's Knight 256 NJ 404,422 2014. The court distinguished previous cases before the court in State versus Mingo and State versus Williams of turning over inculpatory evidence. The court in Knight also rejected Sixth Amendment concerns. Quote, no such concern is present in this case, however, in which the item in question is physical evidence and not the product of defense counsel's investigations. That's Knight at 423. Significantly, Knight uses the phrase, quote, potentially in defense counsel's possession rather than actually in defense counsel's physical possession. In this case, we know that defense counsel physically had possession of a screenshot of a communication between Caitlin Caneiro and Jennifer Caneiro, where the document specifically shows that at some point in time, the text message was read. That item was never turned over to the state at any point in time until well after the testimony. The court now applies this legal framework to the two pieces of electronic evidence at issue in this case, beginning with the text message screenshot. Here, the text message screenshot depicts electronic metadata showing that a message sent by Katie to Jennifer now displays a status of, quote, read, end quote. First, as to the origin of the screenshot, the, quote, read, end quote status was created by the iPhone messaging system, not by defense counsel. When Jennifer Caneiro's phone or other device logged into her iMessage account, opened Katie's message, the messaging system automatically generated the, quote, read, end quote status and transmitted that information back to Katie's device. This is a function of how the iPhone iMessage system operates. It's not something that defense counsel created, directed, or had any role in producing. Similarly, the screenshot itself was created by Katie Caneiro, not by defense counsel. Katie took the screenshot on her own phone and then transmitted it to defense counsel. Under Knight, this electronic evidence, quote, falls squarely within defendant's required reciprocal discovery obligations, end quote, because it is, quote, not the product of defense investigation or attorney work product, end quote. Second, as to the discoverability, the text message screenshot unquestionably qualifies as electronic stored information. It is a digital image file depicting electronic metadata from an iPhone messaging application. It is stored on Katie's phone and was transmitted electronically to defense counsel's phone or computer. This is precisely the type of electronic evidence that Rule 3:13-3B2B contemplates. Moreover, defense counsel actually received that screenshot on February 8th, 2026, according to defense counsel. Defense counsel had that screenshot in her possession when Katie testified on February 9th, 2026. Thus, defense counsel had actual physical possession of the electronic file. The fact that defense counsel chose not to introduce the screenshot as an exhibit at trial does not change the discovery obligation. Defense counsel's strategic decision about how to use the evidence, whether to present it through testimony describing it or through introduction of the exhibit itself, does not eliminate the requirement to disclose it to the state. It's Discovery Rule 3:13-3B2B. Finally, the defendant's argument assuaging noncompliance are unavailing. Under Rule 3:13-3F, there is a continuing duty to provide discovery. The fact that the defense counsel received the screenshot only one day before Katie was scheduled to testify, according to what she has said, does not excuse the failure to disclose. Further, the defense's reliance on tier misunderstands the distinction between tier and night. Tier protects defense counsel from being compelled to create written summaries or oral written statements. Tier does not protect defense from disclosing independently created evidence that defense has the ability to obtain and had it in her possession. Because the screenshot was created by Katie and the messaging system, not by defense counsel, Knight requires disclosure regardless of whether defense counsel ultimately introduces it as an exhibit. Therefore, this court finds the defendant violated its discovery rule obligations as it relates to the text message read status of the text message between Katie Caneiro and Jennifer Caneiro. As to the GPS, the iPad location data was created by a location sharing service or application, not by defense counsel. While the parties have not identified the specific service Katie used, common location sharing services include Find My Phone by Apple, Life 360, Google Location Services, and similar applications. These services use GPS technology to track the location of devices and share that location information with authorized users. When Jesse Caneiro's iPad shared its location with Katie's device, the location sharing service generated GPS coordinates, timestamps, and other metadata showing where the iPad was located at various times. This data was created by the technology, not by defense counsel. Defense counsel played no role whatsoever in the genesis of this electronic evidence that was created by the witness's actual iPhone. First, location sharing data is unquestionably electronically stored information within the meaning of Rule 3:13-3B2B. The rule specifically requires disclosure of electronically stored information and any other data or data compilations stored in any medium. Defense counsel states that the defense simply has what was verbally relayed during a recent witness prep session. However, the test under Knight is not limited to evidence that defense counsel has already obtained and is physically holding. Knight uses the phrase, quote, potentially in defense counsel's possession, end quote, indicating the test extends to evidence that the defense counsel has the ability to obtain. Defense counsel argues that Tier protects Katie's testimony about what she observed because defense counsel has no written statement or document to turn over. Defense counsel contends that Katie simply told counsel orally what she saw, and Tier holds that defense counsel need not create a written summary of the oral statement. This argument fails for the same reason it fails with respect to the text message screenshot. The issue is not whether defense counsel must create new work product summarizing what Katie said. The issue is whether defense counsel must obtain and disclose independently created electronic evidence that exists separate and apart from any work product, or at least to ask about it. Caitlin Caneiro did not merely remember seeing something. Katie used a location sharing service that generated electronic data. That data exists or existed in electronic form. It was created by technology, not by defense counsel. If defense counsel had the ability to obtain the data from Katie, then defense counsel should have requested it or at least indicated to the state that it does not exist.
How long is this decision?
TIER protects, as I indicated, work product created by defense counsel. TIER does not protect defense counsel from the obligation to obtain and disclose independently created electronic evidence within the defense counsel's control. I should also point out, as it relates to the location sharing, that defense counsel indicates in a footnote on page 2 of her brief that she must have learned through her conversation. I'll just use her words. It should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it, either via text message or phone call, once she saw that she had the location, and asked him why he taken Jesse's iPad. Why he had taken is probably what she meant to say. Corey then turned off the location. However, so in that circumstance, that is more information that if the state had that information in advance, would have had the opportunity to actually investigate whether that phone call or text message actually existed, had the opportunity to reach out to Corey Caneiro, and if they wanted to or so choose to figure out if that existed, to get other phone records in this particular case, which at some point they did not feel that they needed at the time that they originally interviewed her. What happened here is that defense counsel put the state in a position by not providing any information as it relates to that metadata for the location services, puts the state in a position where they did not have the opportunity to even investigate, which is exactly what I said from the beginning, that State versus Knight talks about, that the thrust behind reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. Okay. So, with that being said, defense counsel devotes substantial portions of the written submission to arguing that Keith Caneiro was available to the state for more than 6 years, and that if the state wanted to learn about the evidence, the state could have re-interviewed Katie at any time. This argument fails to excuse the discovery violation for several independent reasons. Number one, discovery obligations are independent of the state's investigation. Under Rule 3:13-3B, it imposes discovery obligations on the defense that exist independently of what investigative steps the state has or has not taken. This rule does not contain an exception stating that a defendant need not disclose evidence if the state theoretically could have discovered it through independent investigation. If defense counsel's argument were accepted, it would eviscerate the reciprocal discovery rule. Under defense counsel's theory, a defendant would never have to have a discovery obligation with respect to any evidence that the state could have found on its own through a diligent investigation. This would include written statements, documents, physical evidence, and electronic data. The defendant could simply wait to see what the state discovers and then spring any additional physical evidence or electronic data, arguing that the state should have investigated more thoroughly. Second, the evidence did not exist when the state interviewed Katie. Defense counsel argument in that area also fails. The state interviewed Keith Caneiro on November 20th, 2018, the day after the murders. At that time, the text message did not yet display a read status because Katie had not yet checked it after Jennifer's death. At the time, Katie had not yet tracked the iPad location of Corey's residence because it did not occur until February 2019, several months later. The state cannot be faulted for failing to ask Katie about evidence that did not yet exist at the time of the interview. The notion that the state should have conducted follow-up interviews with Katie every few months for the next 6 years on the speculation that she might someday check our old text messages, track an iPad location is unreasonable, and this court finds no support in law. Defense counsel argues, as a third point, that it would be unfair to penalize the defense for recently learning information that the state could have discovered years ago. This argument actually supports the state's position rather than the defendant's position. If the timing of when parties learn information matters for purposes of fairness, then the relevant comparison is not between when the state first interviewed Katie in 2018 and when the defense counsel interviewed Katie in 2026. The relevant comparison is between when defense counsel learned about this evidence and when the state learned about it. Defense counsel learned about the iPad location on either January 30th, 2026 or February 8th, 2026, based upon defense counsel indicating that she had prepped Katie Caneiro for the first times for her testimony on these two particular dates. Defense counsel obtained the text message screenshot on February 8th, 2026. Katie testified on February 9th, 2026. Defense counsel had somewhere between 1 day and 10 days to disclose not just the evidence for the text message, but also the iPad location information so that the state could have had the opportunity to take a look at it and investigate it. The state has literally had zero time to investigate any part of this information, to verify it, to contradict it, to subpoena for more information or anything in that matter. If fairness and timing matters, as defense counsel argues they do, then the fair result is to give the state the same opportunity to investigate that defense counsel had. That is precisely why a continuance would be accomplished if it was requested by the state. There are questions here that the state cannot answer simply through cross-examination of Katie Caneiro. These questions potentially require investigation, consultation with technical reports, forensic evidence of Katie's phone, review of service provider records, and potentially interviews of other witnesses, including Corey Caneiro himself. The state cannot conduct this investigation while Katie is on the witness stand testifying before the jury. The state would need time to investigate before the evidence impacts jury deliberations. The state has indicated before they heard my decision that they would that they did not want a continuance for any reason. However, before I finish this opinion, I'm going to give them the opportunity after hearing the opinion to make any decision that they would like to make. The court is relying on 3:13-3F, where the trial court is afforded wide latitude to resolve discovery disputes. Moreover, in appropriate circumstances, the court can either order discovery of items beyond the scope of the discovery listed in Rule 3:13-3. However, in this case, under the circumstances, the court is not going to use the draconian remedy of actually barring some of this evidence, and I'll go through it in a minute, but the court would consider a continuance for the state if they needed more time to look at this.
We say no.
However, let me say this. As it relates for the rationale behind the reasoning for the GPS testimony.
Got caught and got yelled at. Not even a stern talking to. Started out that way. He's practically breathing fire.
The defense says this testimony is relevant because, and this is relating to the GPS location of where Jesse's iPad was located for two reasons. One, it demonstrates that Corey was taking items from the house after the homicides which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vote's Detective Vote.
Oh, he's picking
Picking
out
somebody out. Yikes.
that person.
My apologies, that was the third time.
The third time for what?
Cell phone or something, probably.
Can we go off the record for a second?
Judge, off. Why?
We want to know.
What is happening
We
today?
want to know. It's the third time he did something. I want to know what it was. I'm nosy. Come on.
Right? What? Oh my gosh. Today,
Maybe he's
finally.
taking pictures or something, but the jury's not in there right now.
Mm-mm. Mm-mm.
And apparently people are texting from inside.
Mm-hmm. Interesting. Everyone has lost their shit. Oh, yeah.
Maybe he was on his phone.
For the record purposes, an individual was removed from the courtroom for reasons for the sheriff's department to take care of. I just want to go back and say for the two reasons why the defense believes that this is admissible. The GPS locations. It demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vote regarding the Tiffany's jewelry boxes found on top of the fire rubble, both of which occurred prior to Vote's collection of DNA samples in 2020. Second, that it demonstrates a failure to investigate for whatever reason. The police did not seize or search the iPad, while they did seize or search Sophia's phone. I will take them in order. As it relates to any type of Corey's taking of these items out of the house after the homicide, the court had rendered a decision on January 27th, 2026 in a 42-page opinion outlining what behavior that and what instances that would be allowed to be elicited by the defense of either Corey Caneiro or if there were certain other witnesses that took the stand as it related to Corey Caneiro. The court in that order court specifically said that it was found as wholly inadmissible any alleged post-crime suspicious activity involving Elisa Caneiro and Corey Caneiro. In this circumstance, the allegation that Corey went into the home and took out the iPad allegedly, because at this point in time, there's testimony about a GPS location. I don't know if the state's going to end up asking for the for a period of time to actually look at the witness's phone to find out if the GPS actually is there or not. But right now, we only have testimony about that. And the reality is, I have no evidence in this case other than that at some point in time, potentially, Corey had Jesse's iPad. I was supplied in this submission by the defense a photograph of
what kind of morning it's been.
The kitchen of Keith Caneiro's home that had an iPad there. That iPad, whether that's Jesse's or not, that's what is being offered by the defense, that it's Jesse's, and that Corey may have taken it. But Corey also was responsible for taking over everything after Keith and his entire family was obliterated from this planet, and Corey was left to handle all of the issues that were relating to the estate of this. So I can't find under these circumstances that Corey taking items from the house is relevant. I find that under 403 that it actually would be a confusing issue for the jury, because the probative value is significantly outweighed by the prejudicial effect of trying to understand first, was it Corey that actually took it out of the house? Was it somebody else that took it out of the house and gave it to Corey at some point in time? Was it, who knows? The answer is that no one knows that. There's no testimony to that. There's no connection that has been shown, at least at this point in time. So the fact that the allegation is that Corey took items out of that house is not something that this court finds that would overcome a 403 analysis. The second issue is one that's something that's more in line with what I can understand. The second issue deals with a failure to investigate because the police did not seize and search the iPad while they did seize and search Sophia's phone. As it relates to what the investigation revealed and what it may not have, what they did and what they didn't do, that is relevant overall in this particular case. The issue in this case is whether there was other evidence in this case that would point to a different individual other than Paul Caneiro. And the investigation and looking into other areas such as the iPad, I do find to be relevant. I do not find under 403 that its prejudicial effect would be outweighed by the probative value. So I am going to, for purposes of this testimony, that I will allow the fact that the iPad has been was taken out of the home. However, the testimony as it relates to the GPS location is something that I'm going to strike from the record. There is no relevance to that other than under 403 as an overall thing, that there would be a confusion, that the prejudicial effect because of that confusion outweighs any probative value. So we can handle that in one of a few ways. Number one, there can be an agreement that Jesse's iPad, that there can be a stipulation that Jesse's iPad was not searched, was not taken and or searched, or some other type of stipulation that you can come up with. But there will be no testimony as it relates to this iPad until someone can give me a proffer in advance of exactly what's going to be said about it. Defense counsel, out of fairness to the defense, offered up some suggestions. I'll leave it to the state and the defense if they want to come up with something that would be, that they feel would be fair to both sides. However, the admissibility of the GPS location as it relates to the two reasons why that the defense wants to bring it in, the court does not find under those circumstances that it would allow the GPS location in. Again, it will allow the fact that the iPad was not seized or searched, but as it relates to GPS location, this court has difficulty with understanding how there is a connection between where the iPad was located, especially when the defense is specifically saying in their submission that they are not saying that the iPad was taken during the murders, that the iPad was located still at the house after the murders, that there's no connection to Corey Caneiro or third-party guilt as it relates to that particular iPad, that I do not find a connection there under Codaditch, and I would not allow that in for purposes of any third-party guilt. But like I said, I would consider it for purposes of a failure to investigate. As it relates to the text message, as I indicated, I'm going to ask the state now, if the state would like some time to investigate and/or whatever that they need to do, I would entertain that. If the state decided that they did not want time to investigate, I am going to give them latitude as to the cross-examination in this specific area of the witness as it relates to that screenshot and how it was provided, when it was provided, and how that all took place. So with that being said, that's the court's decision that even though I do find discovery violations on both, I find that under these circumstances that the draconian remedy of excluding them for the reason of a discovery violation is not what this court is doing. However, in looking at the actual items, I have made rulings as it relates to my understanding of the evidence rules and how it should be allowed in or not allowed in. So with that being said, to the state, I'll give you the opportunity to let me know if you want what your preference is under the circumstances, and also if you want some time to speak to counsel as it relates to a stipulation as to the second part of Jesse's iPad.
Sure, Judge. I think Ms. Wallace is going to talk to Ms. Mastalone about the iPad. I'm going to go inquire. I highly doubt I'm going to ask for any more time other than 10 to 15 minutes just to think about it.
Okay.
The only question I had, Judge, with respect to clarification of
Sure.
the court's order, obviously they heard it was read, part of that testimony, but we got that document in the brief last night. Is the defense allowed to utilize the actual screenshot?
Well, let me ask you this question. Does the state, under the circumstances that it's been put in, would you want to use that on cross-examination and to go in the circumstances surrounding that testimony that you already have? Because as I indicated, I'm going to give some latitude because of the fact that I do find it is to be a violation, but I do find that under these circumstances that I'm going to allow it in because somebody opened it. It's already out there. And I don't think that I can clear that out of the jury's mind. And I think it's really at this point in time the preference of the state. And again, if you want a few minutes to think about that, I'll give you the opportunity to do it. And again, if you need more time, then all you have to do is ask for that. And out of fairness, I would give you that opportunity to have more time. I don't want anyone, either side here, to sit here and worry about the trial and how long the trial is going or how quickly it's going. It's truly your own prerogative for the state. And you, Ms. Wallace, should have the opportunity to think about it now that you have my decision.
Okay, Judge. Yeah, I would just like a little bit of time to think about that.
Okay, well, why don't we meet back here at 10:45? I'll give you 30 minutes. If you need more time, you can let me know. We're going to tell the jurors downstairs we're in a little bit of a holding pattern, and I'll have Amor do that. I won't address them myself, just to let them know so that they get an idea of what's going on. Okay?
Thank you, Judge.
All right, thank you.
Okay, Llama, clear that up.
The judge, they were talking about the apparent screenshot of Katie's message to Jennifer that then at some point was marked as read. Because they put it in the brief, the judge is going to allow it in. And that's why he's giving the state more time to decide if they want a continuance so they can maybe, look over or have, one of their investigators, authenticate or whatever. So he's giving them time to think about what they want to do with that. If they want the day off or how much time they need. I don't think that's going to be their answer, to be quite frank. But because they could always come back on rebuttal. You just bring the phone person back and just be like, hey. Now, we just learned that they did do a brief look into Jennifer's phone records. So that was new. We've been under the impression that hasn't happened the whole time. Now, back to the iPad, because y'all have some questions in the chat about the iPad, about Jesse's iPad. They believe that the iPad that was in the kitchen, all right, because in the kitchen there was an iPad, there was a laptop, and there were cameras. I think that was the third electronic. They believe that was Jesse's. Now, investigators did not confiscate the iPad. They just left it there. And the iPad later, according to Katie, was that it was tracked back to Corey's house. Now, the kitchen, there were several parts. I mean, listen, the whole house had smoke damage. Yes. It would have had to be bulldozed anyway, probably. But the kitchen specifically was really more just smoke damage than fire in a lot of parts of it. And that's why the kitchen, we have all of that blood evidence from Jesse, and Jesse wasn't burnt like his mother and sister. So that's how the iPad survived the fire, in case you were wondering about that. Now, does it matter? Not really. And that's kind of what the point the judge was saying. Like, the state didn't confiscate it and do an investigation, and the defense hasn't confiscated it and done an investigation. So it's kind of a moot point if it was there during the investigation and then went to Corey's afterwards. That's not really relevant. Now, if it had disappeared during the night of the murder, then that would be a, different story.
It was there in the initial investigation. They have pictures of it. And also the judge said something, that Corey was in charge after that of the estate. So it wouldn't be unreasonable for him to take stuff.
Yeah. I mean, there's some, not great things about that, but that doesn't, again, equate murder. So would have been in the room with him.
There were 2 discovery violations, though.
I mean, not necessarily. They could have had no electronics in the bedroom. They're pretty young. So I think it being in the living room and not in his bedroom isn't really that out of the ordinary. So I mean, my kid wasn't allowed to have his stuff in his room until junior high. My son
didn't have he didn't have a computer in his room the whole time he was living at home with me.
Mm-hmm.
It was out in the living room. I mean,
Mm-hmm. Now, I don't remember where it was located in the kitchen. I know there's a laptop on the island. Was the iPad on the island too, or was it plugged in over by the knives? It might have been plugged in, so he could have been charging it there. I don't know.
Yeah, and a lot of parents don't let their children have their electronics at night. They want them to go to bed. They don't want them on them all that long. That's not unusual to me at all.
You think you need to have a teal and purple robe made for the judge? I mean, is the person who's guilty. I mean, again, though, it was well after the fact of the investigation. I mean, if the house gets turned over to Corey, whatever Corey takes, don't get me wrong, it doesn't sound like Corey was super great to deal with, according to some rumors. That he wouldn't allow Jennifer's family to go in and retrieve stuff. Suspicious, yes. But, I mean, he had access to the house after the fact.
The iPad was in the house the night of the fire. There's pictures of it there. Yeah. So it's not like whoever set the fire took the iPad. That obviously didn't happen, according to the photographs.
Yeah. Now, another thing is that it also hasn't been traced to even be Jesse's iPad in the picture too. And that was the other problem, which is also, maybe kind of an issue. We're all assuming, including the court, that is Jesse's iPad that was in the kitchen.
We don't know of another iPad in the house, do we? I mean,
not that I know of, which is kind of
Yeah.
weird. I feel like
Yeah.
they'd have a few, to be quite honest, but
well, I mean, not if they use laptops and stuff or their
Yeah.
phones. You know,
yeah.
I don't know. I don't have an iPad.
Well, we know though that he didn't take it until after the investigation, because if he took it before, it wouldn't be in the photographs of the kitchen that is covered in soot and smoke and blood. So it was still there. Now after, because the cops did not take it, then Corey had every right to take it. So
I think the blood on the clothes
and that's
and
just
the
shitty
ballistics
investigation.
outweigh anything else. I mean, to me, they do.
Mhm.
That's in my opinion.
Yeah, I mean the not, trying to see whose iPad. I mean, that is just poor investigation to not
Yeah.
determine whose that was. So I mean, that's a fair point on that. Yeah, we don't know. And again, they should have confiscated every electronic, damaged or not.
No, I agree with that.
I do have some, qualms about this investigation in general. It's kind of shocking, some parts of it, for a quadruple homicide, especially a quadruple homicide of a wealthy family, but okay. And that's, one of them there. So, but we do know it was there that night. So, what else did he have to say? That was pretty much it. You guys, if you weren't here for the start of court this morning during lunch, go back and watch the judge get pissed. He was so angry this morning at Monica. It was, oh boy, I haven't seen a judge like that. I think the last judge I saw that really got like that pissed and kind of yelled at attorneys was the Parkland shooting trial. That judge got very, very upset at the defense quite a few times. But even then, I don't know if it was like this one. And he wasn't wrong, So, well, yeah, we don't know if it's a moot. That's why it's a moot point. It doesn't really matter the iPad's not coming in. The only thing that's coming in is the screenshot of the text message that's read, because we did not actually hear her say yesterday that it was at Corey's house. They cut it off right before, they had it on record, which was very confusing. But we didn't hear that yesterday. We're like, left where? So, now I had on my bingo card that we were going to do closings today, but I don't think that's going to happen.
No, I mean, even if they get this settled, it won't be until tomorrow, probably. Just because the judge is not going to be in the mood to start listening to it. In my opinion, he's like, he's already done with this day.
Right? You're like, oh, does Llama have an appointment tomorrow that she can't be around for very important things? Yes. Cool. Let's do it that day. No, I don't know if closing arguments are coming. That's pure speculation on my part. By the way, everybody, I don't know. It's just based on things that the judges said yesterday. Court TV said yesterday. And even today, the judge was like, if you want more time, like, was basically like, listen, I know this is about to be over. Don't say no just because you want this to be over, basically, was what he was saying in not so many words. So, what a day. Well, we've all earned today. After the morning that was yesterday, we've earned it.
Oh, yeah.
Night in 2 different trials. So,
They said this trial was moving fast. Monica?
Yeah. The defense was complaining about how fast it was moving, as we all sit here every day like, This is the slowest hours of my life.
They must have really had some slow trials then. Or else
Right.
maybe they've settled everything and haven't really done any trials. Just because
Well,
you've been assigned 50 cases in public defender doesn't mean you've had 50 trials.
right? And maybe 3 would go to
I know.
trial. Now, in Monica's defense, she just came on last January.
Yeah, she's only been on
So,
like a year, so.
you know, that's not a very long time to be on a quadruple murder. So I doubt that she's super prepared for everything, you know.
No, but she did. I agree with the judge that she knew this one. She knew better on this issue.
Yes. And
Because
her
it's
just not,
electronic.
her sitting there trying to argue, like, I get it, you do a little bit, but at the same time, ooh, girl, that's not great.
Clearly, electronic stuff has been pulled out and separate because you can get a hold of it. And it's document, basically, is what the argument is, I guess. It's not somebody telling you something. You got it.
Right.
You have it.
Because if they would have like proffered Katie ahead of time, had a transcription, that they absolutely would have to turn it over to the state because it's been written down.
Which
I mean,
they don't have one.
But the judge in his argument made some really good points. I mean, you could tell he did his research on how this stuff works. He was like, it could have been opened at any time by anyone. It's not really relevant, but he is letting it in, even though I don't think it even meets the rules of evidence, because there's no real data there.
Yeah, I don't know how you say it's relevant, but if you can't pinpoint when it was opened, it was just opened 7 years later. Well, that's what I wondered about the new owner of the number. If something, or when Apple cleared the number, you know what I'm saying? If it didn't open it up at the end and show it as red, even though it might not have been red.
I think that's what the judge was hinting to the state is like, you didn't want to take it out because the jury already heard it and that would look suspicious.
Well, that would only emphasize it more too.
Right. So he's like, I'm just going to let it in because it's already there. And so the state's going to have to argue, you know, that this can happen, you know, for a multitude of reasons. Doesn't mean, you know, something nefarious happened, but that's going to be on the state to like argue, and or, you know, have a rebuttal.
They may do a rebuttal instead of a delay. You know what I'm saying?
Because I do have a question. You know, if they subpoenaed her phone records, we know the phone was never found. And we now know that the phone records were subpoenaed, which is weird because we definitely heard they weren't a couple weeks ago. But anyway, they had. But would subpoenaing the phone records also make the read show up? I don't know.
I don't know either.
You know, so.
Well, see, that's the thing.
And
that's one thing the judge mentioned. He said at the time that they did the extraction, that read evidence didn't exist. So it's not like something they could have investigated. The state could have investigated because it didn't exist at the time. So her saying 7 years later, well, they had her extraction. Well, it didn't matter at the time.
Right.
It hadn't been read at the time.
Well, and I think that's because the message read, that was, she just saw it the other day. And it's been 7-8 years since the murder. So it, with no idea when it was read. I mean, even they said that. So I think that's just what Chris is going to go with and just say, we're just going to remind everyone nobody's checked anything in the last, 7 or 8 years. So it we don't even know. I don't think it's a huge hurdle for the prosecution to jump over.
I don't either. It's an unnecessary one.
But but I do think the judge was really irate today and very strict. So defense doesn't try to pull it again. And I think that's the reason for
because he did say he found 2 instances of violation. So I think if he finds a third one, he may do the draconian thing just because
Maybe.
What are you going to do? You're going to have to teach them a lesson because are they going to do this in front of you again?
Mm.
Maybe.
You know, because they're already on alert if Susan testifies, the wife, because that's when the first instance of this case was brought up, the New Jersey versus Tier.
I may not call anybody else from the family after this because it may be more of the same thing. Because she kept saying I wasn't trying to elicit this testimony, but I think she was. But that's my opinion because I can't read her mind.
Right, but like we all know.
You know.
We all know, girl. Everybody knows.
I know.
I have to go use the
exactly
bathroom.
She got it out exactly what she wanted to get out.
I really have to go use the bathroom real quick. I'm so sorry.
Okay.
We got another 15 minutes. I can't hold
When
it
you
that
go,
long.
I'll go. After you get back, I'll go.
Entertain the masses. I'll be right back.
Oh, so what do you all think? Do you think she was trying to elicit that testimony? I mean, I do. I think she got out what she wanted. Yeah. I agree. She was trying to get that out. I don't know if she's going to try anything like that again, though. I mean, she might. She might feel now that what more damage is it going to do? I don't know. Yeah, she did get away with it. I don't know how the state can bring that out as a, you know, that they did something they weren't supposed to. I don't think they really can, but right, they're trying to make Corey be, I mean, they said it in the openings that Corey had, I don't think they said he did it as much as, you know, he had the opportunity and he had a motive because he got half of the life insurance and all that. But at least they don't know that the iPad is at Corey's, but they may figure it out. I just don't know about the email that gets to stay in, if they'll consider, I mean, it hadn't been checked for 7 years. How would you know when it was read? And how do you know that wasn't a technical thing? So I don't know if they'll bring in a rebuttal witness to say that or just say it in summation and hope they accept it. I don't know. I don't think it's that big a deal, but I guess it could be with some. Of course, you could have some juror who thinks all the defense is a distraction anyway, no matter what they say or do.
That's true.
There's always those.
I drank like a whole pot of coffee today.
Well, apparently Angie and Sam think that she was trying to elicit that testimony too.
Oh yeah, totally.
Yeah. So
yeah, nobody believes her.
Yeah.
That. Nobody believes her.
Dave just went back and watched it.
Oh. Yeah, whoa, indeed, right? Oh,
Yeah.
He's so angry at her.
He was like, what?
I also like how I said earlier that the state was dressed very well for today. Like they are very top notch. And then the defense, they're all wearing brown, like a family photo or something. Andy's wearing his ugly brown suit. Monica has on like a brown turtleneck with a lovely skirt. Oh my God, I love that skirt. And then Paul is wearing his shit brown V-neck sweater with his yellow collar shirt. I was like, I
think that sweater would look much better if he didn't wear that yellow shirt with it.
Oh, it's gross.
It's gross.
Yeah, I don't know why.
I have a brown shirt that, you know, I like to wear every once in a while, but I'm not going to wear it with a yellow shirt underneath it.
Right. Oh, It is an insane distraction. I love it too. So I wondered if like they just dressed down for, I don't know. That's my interesting fashion observations for
Maybe
this
they're-
morning.
Maybe they're all on the same. They've been talking to each other so long. They're on the same brainwave or something.
Oh boy. Monica should have worn brown pants today. Oh boy, right? It does. Yes, because he would wear that pale yellow shirt. Oh, it's not great. Well, we know we're going to get Katie back on the stand at some point today. I think we should all manifest, though, that the defense is going to rest this week.
I'm going to manifest that the state goes after Monica. What is her name, Monica? Caitlin.
Mastiello.
I want Caitlin to get a little. I want her to have a little bit of a heat on her cross-examination of her. A little bit. You can't go after her too hard, but you can go after her.
If I recall, I think it's Nicole.
Yeah, I think she can go after her because she's not the victim's family.
I think, it was Nicole objecting yesterday. So
yeah.
I think it's her.
But Terry, we will make sure that you get to wear pink every day.
Every day. Darker animals. Yes.
He probably did, actually. Or something similar.
Probably. Oh, Garanimals is still around, Dave, just to let you know. I know they make yogurt now, too, or something like that. So, or at least they did several years ago.
Go-gurt?
Aren't we behind? Oh, no, babe. We're 100% caught up. We're not behind at all. I'm sorry. Yep, no. There was a big break before, like we were live when the judge was reading his decision. He took a very long break in between the two, so.
He had to calm himself down. He was still mad, though. You could tell.
Oh, yeah. He was shaking that leg, his whole chair. He was very pissed this morning. I mean, that definitely sounded like he was up all night writing that.
He probably didn't. He was probably a little miffed that he needed to let them have it, even though they had the violations, because he knew it was on purpose.
Yeah.
He knows it was on purpose.
Absolutely.
So that would make me angry too. I don't know how some judges, I don't think that's an easy job. I think some people think it is, but I think it's hard. It would be hard.
I wouldn't want it.
Not to let your emotions get in your way, especially if somebody make you mad and you knew they did it on purpose.
Well, I think, that, and he's already been very annoyed with this trial, as we all have been. So, still looking for a giant wood fork and spoon to hang in the kitchen. Oh, gosh. I know.
My grandparents had that. Thank you. Actually, I think my mom did when I was real little, but they got rid of that pretty quick.
Oh. Oh. Oh, goodness. Well, some point today, the trial is actually going to be continued. Maybe, unless Chris comes back and it's like, we're going to need a continuance. And then I'm going to be big mad. You're going to get a llama rant, Chris. That's what you're going to get. Nobody wants that.
I think if he thinks he can get a rebuttal, which I'm sure the judge would let him do at this late stage anyway, he might go that route because he might need more than one rebuttal witness if the defense does this again. You know what I'm saying?
Yeah. Man, I want to read those like ex parte orders and stuff. I want to know what was in there about Corey that they're not allowed to talk about. Because I'm nosy. That's why we read the court documents, you guys.
Well, maybe
he's in there.
After the trial's over, they'll be released and we can read them.
I feel like somebody found some for this.
Put Angie on that. She finds everything. Her.
Speaking of documents, I was reading through some Laura Owens ones, like highlighting them and writing stuff out for when we start. So I'm very excited about that.
Oh.
You know, some of the Michael Maricini ones that were like hard to read, the text messages and stuff.
Did you find those?
Well, I didn't. I interpreted what they were saying
Did
for the
you?
most part, and I typed them out.
They're hard
So
to
I
read.
spent like 2 hours just being like, is that
I
an
know.
R or an I? Fuck, I'll just put a
I was like-
question mark, I guess.
I was doing too much other stuff. I said, I'll let Mama work. I got to read this other garbage that she's spewing. I'm like, I mean, it was bad. The things she said. Now, I don't know. I'm not saying it's not true. And I'm not saying it is true, but it's still bad.
I'll go with it.
But considering everything that's happened since, I'm inclined to think,
Right?
yeah.
So we will be starting our Laura Owens coverage very soon. And you might be like, Llama, we're going to just be reading court documents. Oh, yes. But some of the most entertaining. Like, I can't wait until we get to 2024 in the midst of the Clayton Eckerd case. Because I read some of the documents produced by her lawyer, David Gringus, at the time. Oh my gosh, they are hilarious. I didn't know that so David Gringus was her lawyer for Clayton, I believe. And
Is that the one she's suing? Gringus? Isn't she suing one of her lawyers?
I don't know. He's the one that might get disbarred, which is no surprise. Okay. But Woodnick, who was also Clayton's attorney, he was Greg's and then Clayton's. Anyway, Gingras wanted to talk to the other lawyer, and the other lawyer is just like, we're not going to be friends, basically, right? So her lawyer puts a motion to the judge to order the other attorney to have lunch with him. And writes a whole motion about why she should make the other attorney go out to lunch with him, and that he wants her to court order a lunch date, basically. Like, what?
And what did the judge say to that?
Well, I didn't get to reading hers.
I just want to know what
the answer was no.
I was going to say, order a lunch date. Oh, that's ridiculous.
Oh my gosh. They're just so wild and so outlandish. So I can't wait for.
The whole thing is ridiculous. And whenever I read anything from her mother, I'm like, where's my salt shaker? The grain of salt out there.
Mm-hmm. I'm so excited about it. I promise you don't want to miss any of those shows.
No, they're going to be on fire.
They are. And it's a lot. I was like, oh my God, I have so much content for like the next 5 months. Just kidding. Probably, but I don't know.
I would say for quite a while, actually. Because when you read something yourself, it's different than when you get to reading it on a screen and discussing it.
Well, that's what I had to go through. I had sorted, the lineup of episodes. And now I have to go back through because, in my mind, as I'm reading them, I'm like, oh, this is a good spot. But then I don't factor in that I'm going to be reading out loud and then there's going to be conversations. And I'm like, oh, that's too much for one episode. We're not trying to be here for 6 hours again.
No, yeah. So I would
like,
leave. It depends. If it's you and Buffy, I would leave double your time for discussion, at least.
At least. Right? Oh, man. So we will be starting that shortly after this trial wraps up, which, yay. Yay. I thought it was so funny. The defense was just like, this trial is moving very fast.
I don't know what they're on. I mean,
they've got nothing. I think it is. They're just like
it's like the runaway train for them, even though it's like the slow motion train for us. Like it's never going to get there.
Yeah.
No, Buffy, I'm saying the two of you, when you get together, you feed off each other, and it's wonderful. It's wonderful.
Oh, we're gonna have a good time. We're gonna have a very good time. You're like, how does this train wreck get worse? Well, it does with every document. It's great. So I can't wait to start that. Thursday, we're starting True Crime and Wine. Well, we had our first episode last night, but we're doing part 1 of Maureen McDermott, Guilty or Innocent on Death Row. Very interesting story. One that you probably haven't heard of. I hadn't heard of it when I started researching and writing it. But certainly, oh man, what I want to do to watch this trial, because I don't know.
When was it? When was the trial?
1990, 89, 90.
It's
I think it's 80.
filmed
I think it was
in
end of
United-
89 into 90. It was several months, which is crazy. But that's probably because their main witness was on the stand for like 12 days.
A
Could you
7-month
imagine?
trial?
Mm-hmm. Mm-hmm.
Well, how much?
Yeah.
I mean, how long was OJ's? His was like,
11 months.
and Menendez, theirs was ridiculous too.
Yeah, theirs was I think about 3 or 4 months. Their second one,
Yeah,
I think, was about 3 or 4 months. I don't know. Wait, which one? The first one is televised, right? The second one wasn't? With the Menendez brothers? I think that's the order. So
Yeah.
the first one was longer than the...
it was televised, and the second one wasn't.
Yes, okay.
And the first one was longer because they got to put in all that
Mm-hmm.
evidence that the judge would let them do the second time,
Yeah.
which I still have mixed feelings about that. But it is what it is by this time.
So definitely don't miss our part 1 Thursday at 8 p.m. Eastern. Terry and I are back. I have a whole bunch of wine for the shows. So that's going to be a good time. And then Friday, for our members, we're doing another episode of TMI. It'll be lots of fun. I'm very excited about that one. Just a regular old show for you guys. And that'll be back this Friday. And then Llama learns about on Saturday for the besties and higher. Yeah. So still lots of stuff. Oh, and Midday Missing's back. Oh my gosh. Sorry, I forgot to mention that. Terry started season 2, Midday Missing, back yesterday. You can find it on our channel. And she'll be doing that Mondays and Wednesdays, uploading them until I think court's done. And then she'll be live with them on YouTube. So be sure to check those out. Very sad, but also so important in trying to get answers for the families. Also, where is court? Yes. Okay, thank you. Because I couldn't remember which platforms it was. She was on Kick, Facebook, and TikTok at 1 p.m. So please go check out her episode from yesterday. And she'll have one tomorrow. Sorry, I had to think what day it was. I was like, oh, it's Wednesday. No, today's Tuesday. Today is, in fact, Tuesday. Good. I'll tell you what, for some reason, February, I can't remember what day it is this month, no matter what. I'm like, oh, it's February already? Oh, yes, we're back. I hear noises. Because I need to go make another pot of coffee. I'm going to go do that while they file in. I will be right back, friends. What happened? Are they not in court? Anybody?
Sounds like the court stenographer's back, but that's all. I don't know.
Okay. So they're
Yeah.
not quite back yet?
No, I don't know what all that noise is. But
Oh, sorry. I didn't really leave you hanging there. I thought they were coming back, so I thought I could go do a couple things and make some more coffee. I'm sorry.
well, you can because they're not back yet.
Well, I did. That's all taken back
Yeah.
or taken care of. Okay.
I don't know what the noise is. Coming from the courtroom.
Sounds like. Oh, by the way, I did see that the reason Court TV is not doing it and quit earlier is because they fired pretty much everybody.
Well, that figures.
Mm-hmm. So that explains why they cut the feed in.
Oh, that's okay.
In the middle of the day. Apparently, they fired most everybody.
I was gonna say, probably called back the cameraman and said, "You're fired. Get back here. Bring back our equipment."
That's exactly what I think probably happened. So.
Well, that's just rude.
My phone. So I have this mystery going on. It's been happening for several weeks now, and it's not just me. Elbow Feet confirmed it. But we kept hearing, like, you know, the noise your phone makes when it vibrates, like, right? That noise. We've been hearing it outside of our bedroom wall, like to the outside, for like several weeks now. And it'll go on for like hours. And we can't figure it out. It's driving me crazy.
Okay. What do you think it is?
I don't know.
That's weird. That would be annoying.
It is. Oh my God. It's so annoying because it drives me crazy. Because at first I was like, oh, am I just like phantom hearing my phone? Because my phone's always on vibrate. Ask Terry, who wasn't until 11:30 last night that I saw she called me at 6. I like literally never really look at my phone.
I don't either.
But I was like, Elfie, like, do you hear it? Like, it's driving me crazy. And he's like, yeah, I hear it. And it can't just be like, because my house is very close to my neighbors. But it can't be because it was just like plugged in. It doesn't make any sense. I don't know.
You don't have,
you're not our house.
You're not like an attached house, right?
No, it's just there's like a, I don't know, 3 or 4 foot. Yeah. And it's all our, like, not all of the time, but like large hours at a time.
What is large hours?
Please. Is it please? No, because it's the same rhythm as a phone. You know, like, like it's constant. The pace is constant. Maybe someone lost their phone. Well, whatever phone they have has the best freaking battery ever. And being waterproof, because there's been a foot of snow outside for the last several weeks. And that's when it started, was when we got that foot of snow, which was like the first.
Have you been out? Is the snow gone?
No, it's starting to be gone today.
Can you go out and look where the snow is, where you hear the sound, and see if there's something laying out there?
Maybe. See, that's what Elbow Feet thought. He's like, oh, it could just be the electricity noises. And I was like, okay, never heard those before.
Is the house going to burn down?
Right? Like, that's alarming.
Yeah, that doesn't make me feel better.
I don't know. It's a mystery. And it's driving me mad. Because I'll hear it sometimes at night when I'm trying to go to sleep. Don't like it. Don't like it. Are you near power lines? I mean, yes. Because I live in the city, so. Coming from the wall or the outside. It sounds like the outside. Well, it definitely sounds like it's not in our room. That's for sure.
Maybe you have a peeping Tom who's getting called by their spouse saying, get in here, quit looking in their window.
Maybe. That happened to you it was a fly cocoon. What horror is that, Liz?
Oh my gosh. You know what that means, don't you?
Oh no. Oh,
you know what that means, don't you?
I don't know. I'm not going to Google it. I can tell you that. I'm going to live in my naive bubble.
What grows in or changes into fly?
I know. I'm just going to.
Oh, God. No, I do
have
nightmares about one of those. I've never seen one, but now I have a nightmare about it.
Things Llama will, new fear for Llama. Llama will not be learning.
No.
About fly cocoons.
No, I will miss that episode because you know how I feel about those things. Woo.
I don't know what it is. It's driving me crazy. Great. I got to think about that all day.
I know. No.
Because see, Elbow Feet's theory was that it was the electricity from like how cold it was or something. That it was humming because of how cold it was, and I was like, I don't even know.
If it was working overtime or something.
Yeah, I don't know. I mean, he's probably right. His work is locating utilities and stuff.
Yeah, but he also finds bees and ticks. Okay,
that's true. That's true.
He's a magnet.
The chupacabra laid eggs.
Oh.
The people need to know. They don't need to know. Mm-mm.
No.
Oh, I bet the jury is annoyed. I'm annoyed.
They were all thinking we could have slept in today.
Right?
Because they didn't get that much of a late start. Just about an hour for them.
Oh my gosh, Liz. That's
now,
awful.
let's not even talk about that. That sounds like a nightmare.
Right? Stuff nightmares. Oh my gosh. No, in fairness, I have not heard the buzzing in the last couple days, but I've also had the TV on. So I think the last time I heard it was, today's Tuesday, isn't it? I gotta send Elbow Feet a reminder that little Llama has scouts today. Will you still be home?
Court is back in session.
Okay. Everyone can be seated. I'll see the attorneys at sidebar.
Oh, perfect. What have we been doing this whole time? All right. Do I have a clock radio? No. No. And there was no extra electronic gadgets in my room or anything like that. So you fled to New York. Ugh, I don't like that. Yep, they came back and went straight to sidebar. I'm assuming he's asking the state whether or not they want a continuance or not. Could have done it in front of everybody. That would have been great, but okay. Don't yell at me. I'm not using my mom voice. Jeez. Please don't ask for a continuance. I just want this trial to be over with. Like I can sense we're almost there, but knowing our luck, he'll be like, nope, we're going to need a whole week, sir.
It's like when your child is involved in sports and you're in the tournament and you're like almost over there hoping your child's team loses. So you can go
I'm so glad that little Llama is not athletics is not his strong suit. And I'm happy about that. I'm so glad not to be a sports mom, to be quite honest with you.
Well, mine only did it until he was like through elementary school. But yeah.
Oh, thank
See,
you.
Sammy knows what I'm talking about.
Sammy's a sports mom.
Yeah, she is.
She is. I am not, thank goodness. Because, especially football, I can't even do football ever. Bees on phones. Maybe
it's what was it on Saturday Night Live? They used to do the sharkogram. Maybe you have a beogram.
Maybe. I don't know. One of these days. Oh, boy. I'm wondering if that lady in the purple, is that lady in the purple like his other daughter or something? Or is she part of Jennifer's family?
I don't know. Wouldn't she be on the other side if she was Jennifer's family?
No, because Susan's sitting right behind her.
Okay.
And Katie's been in the courtroom for quite a while, at least over the last week, because I've been wondering if that was her, because I noticed that when that woman would get up to leave that she was pregnant. And I had heard that one of the girls was pregnant.
Well, maybe that's one of those where they just sit wherever. Well, they are, because they are seated behind the other. The attorneys are. It's not like a side.
Mm.
Right?
Yeah.
Okay.
Yeah, they're all sitting pretty close together, which I found to be interesting. So
it is kind of tight in there, isn't it?
Did I check the ceiling fan for the noise? Do not have a ceiling fan in my room. I'll say it sounds like it's outside of my bedroom wall, but towards like the ground or something. I mean, it doesn't mean it is, but that's just where I think.
That's just how it sounds.
Yeah.
Do you have a window over there on that side where you hear the noise?
Yes.
Okay.
Yes. So, I don't know. Monkey butt makes up for little Llama. I know monkey butt's involved in all sorts of things. Little Llama, ugh.
Well, he still does orchestra, right?
Yeah.
Yeah.
He does orchestra. He makes like video games for Roblox.
That's nice.
Uh-huh. And then for Christmas, he got like this electronics like chip circuit kit thing. I don't know. I don't know what any of that stuff means.
Oh.
But he also got a soldering iron, which, if this tells you anything about my little llama, that was his favorite thing he got for Christmas.
Oh yeah,
It was a soldering
would have
iron.
loved that too. He would have liked.
And so he made like this, computer chip thing that does something. I don't
My
know.
son took welding in high school every year.
Mm.
Well, he liked the teacher a lot, but he also liked, and he's pretty good at it.
Yeah. Yeah, he's really into, electronic building stuff, like robots and things, I guess. I don't know. I just stand there and nod, like, oh, okay. While him and Elbow Feet just have like a whole conversation. I'm like, I don't know. Choose to not have kids was to avoid all girl. Yes. Yes. Oh man, the whole school dealing with that again after like you've been out for so long, just annoyed and angry about it all the time. At least I was. Like, why am I being punished? Okay, why do I have to get up and take him to school at 7:30, 8 o'clock in the morning? What is this?
What did I do?
Fair. Yeah,
I just had a kid.
That's what they should tell teenagers to
Yeah.
avoid getting pregnant. Be like, do you want to keep staying up till 6, 7 o'clock in the morning and still have to participate in all this school stuff that you don't go to? No. No, thank you. No, thank you. I love when it's summer vacation. Oh. I'm also glad I don't have to take my son to school. Because let me tell you what, there's also a circle of hell that is just school drop-off and pickups. If you've never had to experience...
Online, you mean?
Yes.
Yes.
Oh, my God. It's the worst. It's the fucking worst.
Well, will they have transportation for his school? High school?
Well, that's the funny thing because...
Depends on which one.
Well, no. The city, because they're running out of money, it's a whole thing we won't get into, fucking school vouchers and people that don't have above a 6th grade reading level. Anyway, the school is running out of money because they have to bus a bunch of kids to private schools. And when they don't do that, they get fined. And they've now been fined like over $3 million because we don't have a way to do that. Like, our city school system is over 50,000 kids. Like, we have the largest school system in the state. And anyway, we won't get into all of that. So now the city school district is talking about not busing high school students at all, which is insane because they're like, oh, well, they can just take like the CODA, the bus system. I'll tell you what. That's not going to work. These people have obviously never ridden the bus. Okay.
Well, it's not like a straight shot either.
Exactly.
Change buses and all that stuff.
Most of the buses, except for like, there's 2 buses, the main ones that they come like every 15 minutes or something like that. But most of the other buses come once an hour. So if one of these kids miss the bus, they got to wait a whole nother 30 to 45 minutes. Then if they have transfers, like, listen, I took the bus to go from my house to work. It was fucking awful. And now you're expecting, if I drove, it took 8 minutes. If I had to take a bus, an hour and 20 minutes.
Yeah.
And you're expecting teenagers.
They'd have to change the bus routes. Like you said, you couldn't, if they miss the bus, they can't wait an hour on a bus. Mm-hmm. That's not safe.
No, let alone it's like, listen, I don't take the bus anymore for a reason because it wasn't safe for me, let alone a bunch of teenagers. Like that's, I'm so just mad about it.
Is that they require your child to go to school by law.
That's
sure.
They should get them there.
No.
Ladies and gentlemen, we're going to break to give the state a little bit more time We'll start back up at 1:30.
Are you fucking recording? Well, friends, I don't know what to do about that. Cool. So we're on a 2-hour break. Cool. Love that for us.
Well, maybe the state needs to look into it more if they can find some kind of expert. I mean, to help them out with their cross. I mean, you know what I'm saying? I don't know. That almost sounds like they're going to have to do a rebuttal if they want to. I don't know.
I think so too. They're probably waiting. They probably reached out to the phone people, or they're just waiting for a response. Maybe. I don't know. Oh my gosh. I know. I don't know. I think here's what we're going to do is we're just going to go off air for like the next 2 hours and come back at 1:30 and just do this as a 2-parter. Because I can really use this time to work on some other stuff right now. But also, we'll see if they come back then. How annoying. Oh, I bet the jury is not happy today.
No, because they could have been home doing stuff or.
Tracy, I'm just getting here. Why the 2 hour break? Girl.
Oh, you got to go back and watch from the start. Ooh.
Yes, you will have to. It's been a spicy day. The judge went off on Monica this morning. So, I mean, I'll fill you in, but you're going to want to go watch it for yourself. It's totally worth it.
Yeah.
But basically, we're waiting for the state to decide if they want a continuance based on some testimony yesterday. And now we're on a 2-hour break to see if they get whatever they need for this. So it's kind of a mess today. And
Judge was shooting fire daggers at Monica.
Yes. Fire daggers. So, oh my goodness. It was a day. It's been a day. So, well, I guess there it goes. They're not going to do closing statements today. Damn it. But, well, on that note, I don't really have a whole lot to say. So if you've missed this morning, okay, please go back and watch. All right. There's a lot of large breaks. So just fast forward through those. I mean, we can only talk about so much during these.
Yeah, but you don't want to miss the fire and you don't want to miss the fire.
The fire and why the judge is still super pissed. Anywho, all right. Well, I will be back at 1:30. Don't you work today?
No, but I have to go to my parents. So.
Oh, that's right. Okay, I was like, I knew you had plans today for something. Well, I will be back at 1:30. Lane, great. I'm glad you got to join me this morning when something interesting happened.
Oh, I am too. That was nice to speak. It's like something to talk about.
All right. Oh my gosh, I can't even tell you how bad I felt yesterday. Like, oh no. Oh, no.
Yesterday, if I drank, I would have been drinking all night.
Right. Oh, when sent me some wine and I said, I promise I won't drink it no matter how much Andy makes me want to drink it.
I know. I mean, if you started dating with Andy, wow.
It's rough. It's rough.
Yeah.
All right, everyone. Well, thanks for joining us this morning, and I will see you. No, I'm not going to leave the word game running for you guys. So we'll just do a whole new stream for this afternoon. So I will see you all then. All right. Go forth and be amazing, friends. Bye.